Hello, everyone. My name is Anthony Niblett. I'm a professor at the University of Toronto Faculty of Law. I'm also academic advisor to the Future of Law Lab at the faculty. The Future of Law Lab is a place for students, faculty, alumni, practitioners, and policymakers to come together and discuss big issues relating to innovation, the law, digital economy. And one enormous current topic of debate is the future of Canadian competition policy. The federal government recently released a paper seeking consultation on some possibly dramatic changes they're exploring. To talk us through where the government may be headed with this, we have a stellar panel of experts from academia and practice. We've got my colleague, Ed Iacobucci, professor and TSE chair at the University of Toronto Faculty of Law, and also C.D. Howe Competition Policy Fellow in residence. We've got Danny Sokol, Carolyn Craig Franklin Chair in Law and Business at USC, Margaret Sanderson, Vice President and Practice Leader in Antitrust and Competition Economics at Charles River Associates, Sandy Walker, Co-Chair of Competition and Foreign Investment Review Group at Dentons, and Randall Hofley, a partner at Blake's. Thank you all very much for joining us today. We've got lots and lots to get through. Ed, if I can talk to you first, turn to you first, perhaps you can just give us a bit of background as to how we got here, some context, some of the concerns that people have regarding the current state of the law, and why it is the government is thinking about making some of these rather dramatic changes.
Thanks, Anthony. And so I'll answer that set of questions through sort of my personal engagement with it, because there's lots there that I can't answer about some of the directions that in which we seem to be heading. But I mean, my involvement with this sort of began with some conversations with two former then directors, now commissioners of competition, with Lawson Hunter and Howard Weston, where we were discussing what seems to be a kind of worldwide phenomenon, at least in sort of developed economies, where there's increasing attention being paid to competition law and possible reforms. There's a conversation that started in 2020, and I think it's only in some ways intensified since then. And part of the conversation with Lawson and Senator Weston was a perception and a concern, frankly, that a fair amount of the discussion seemed to be heavily ideologically laden, if I could put it that way. All these sorts of conversations probably are to some extent, but there seemed to be sort of strong kind of visceral reactions in many ways to certain kinds of entities in the economy. Certainly there's been a reaction to big tech that has provoked, I think, a lot of the conversation, some of it quite thoughtful. Others, I think, sort of more, maybe a little less connected to the traditional understandings of what antitrust is all about. So it's kind of an interesting, one of the interesting features of the debate is in the US is that you've got left and right populism on both the left and the right coalescing in their agreement that big tech needs to be broken up in one way or the other, and antitrust law is the appropriate kind of tool to do that. So I think we were, observing all this, obviously expecting something like this to come to Canada, and had the view that it might be helpful to try to make a contribution to the conversation, where it's just trying to connect it to competition law, I think, foundations. And so Senator Weston asked me to produce a discussion paper on possible directions for reform, which he then used as a kind of starting point for consultations. The paper and many of the submissions to the consultation, but not all, thought that the basic structure of competition law in Canada seemed appropriate, but there were certain specific reforms that I think were called for. Wage fixing is not an offense under the old act. The definition of anti-competitive effect and abuse didn't make a lot of economic sense. In particular, it at the time required a harmful effect on a competitor, and that was another area for potential reform. So the paper kind of went over that kind of landscape, made some suggestions. It elicited a number of submissions, including a submission from the Competition Bureau, which was quite wide-ranging and I think provocative in many ways. Clearly, the Bureau was prepared to accept and encourage and push for, I think, more dramatic reform to the Competition Act than certainly my paper contemplated. So that, of course, led to the Budget Implementation Act, last spring, which included a number, I think, significant amendments to the Competition Act. Some of them had been discussed in my paper and other fora. Wage fixing, for example, will now be per se a criminal offense. The definition of anti-competitive act was amended to include acts that have an adverse effect on competition, not just a harmful effect on competitor. Although it kept that definition of a harmful effect on competitor in the definition, in fact, codified case law that had established that feature of the definition. Other changes, I think, in the Budget Act were, I don't think, on people's radar more generally, and were a little bit of a surprise. Certainly not on my radar. Maybe I should just speak for myself. So, just as one example, the merger, amendments to the merger provisions now invite the tribunal to consider degradations, on price, quality, both conventional kind of understandings, a merger that might affect price, quality, or privacy as a kind of independent third consideration that the tribunal should touch upon. So I think some of these amendments were, as I say, had been discussed, were welcome, but I don't think the process was ideal. It was too bad that there wasn't an opportunity to debate the particulars, I think, before they were put into law. And so there's still much that I think is uncertain, and other areas where the changes may be more certain but could have been better, in my view. So one example of the uncertainty, and this is something Erica Douglas has pointed out, what does it mean to include privacy as something independent from quality, right? I think most competition lawyers would have thought of privacy as something that's kind of akin to quality in the provision of a good or service. But if quality is a consideration and privacy is also a consideration, what's the relationship between those two things? It's really not clear, and there's no debate on it because of the process that found this in the Budget Act. Another example where I think there could have been, it was directionally the correct thing to do in my view, but could have been better, was this revision of the definition of anti-competitive acts, which now appropriately includes an adverse effect on competition. One would think that would be a good starting point. And in fact, one would think, in my view, that that's a good ending point. I don't know why they've continued to include in that definition harms to competitors. So all that to say, the process, I think, wasn't ideal for producing the best results. And I don't think in some ways we got the best results. I think they were, in general, directionally sensible, but there's room for, I think, improvement. All this leads to the process that Anthony described, that we now have a paper from ICED calling for more kind of wide-ranging thinking about competition law in this country, saying that the budget amendments were kind of a down payment on potentially more profound changes to come. And I think there's much that this panel can discuss about the substance of that. But I would just say just two things on this process, which continue to, I think, concern me. One is, again, we don't have details. This is a very sort of broad-ranging discussion paper. And what I would worry about is that the government will take this, consultation as an opportunity to then, legislate something specific without further opportunity for comment. And I think that would be a mistake, actually. I think it would have been better in some ways, even if it was just tentative, for the Bureau to do just as, or not the Bureau, but for ICED to do just as many regulators do, have a notice and comment period with something actually quite specific that people can sink their teeth into. I think that would, and there's still opportunity for that, but the government will have to be able to stomach another period, another round of consultations, and I'm not sure that's going to happen. So I think whatever they do, I hope that there's further opportunity to comment. I think that we would end up with a better set of amendments at the end of the day if we had the specifics in front of us. And I think I'll stop there because I know there's lots to talk about on the substance of what the government's mooting.
Fantastic, thanks, Ed. Yeah, let's get into the substance. On the consultation paper, it's broken up into the typical categories you would think: merger review, unilateral conduct, collaboration. Let's start with merger review. Margaret, if I can turn to you, I just wonder if you could just talk us through some of the proposed, some of the ideas that the government's seeking input into, some of the concerns that they have with the current state of the law, do we really need changes? So I'll turn it over to you, Margaret.
Great, thanks very much, Anthony. So I want to talk about two things in the merger review section. One of which follows on sort of the broader themes or the international implications that Ed was talking about, which is a call for changing the Bureau's burden in terms of the legal standard, or thinking about a different, not removing the idea of a substantial lessening of competition, or changing how one would think about that to a balance of harms. And that is, I think of that as coming from the broader push for greater antitrust enforcement that we see happening around the world that Ed mentioned, but it also stems from some Canada-specific issues, which would be a concern that the Bureau has, that it's very difficult for it to quantify non sort of qualitative harms or non-price dimensions of harm in merger review. And that particular concern of the difficulty in quantification in certain transactions really is a Canada-specific problem. And that Canada-specific problem of this overemphasis of on quantification of harm is something that is tied into efficiencies. So I think the two topics really have to be thought of together. And generally, I would say that all of the amendments have to be thought of in a holistic way. One of the concerns I would have in this process is from the ISID consultation, that there's sort of bits and pieces get pulled from different types of suggested reforms, and we don't end up with a coherent whole at the end of it. So that would be a general comment. So why, let me just then turn quickly to talk about the balance of harms notion, which is something that the Bureau, or ISED, is proposed as a way to deal with the difficulty of quantifying harm when you have a lot of non-price dimensions of competition that might be of concern. Privacy, Ed just raised, or other kind of quality dimensions. This comes up in tech in particular. So this would be a change for Canada, and would obviously put Canada in a very different position relative to all the jurisprudence, and also relative to other jurisdictions. So only the UK actually has a standard that would be a balance of harms when thinking about how to evaluate a merger in the tech industry. Now, as a I guess what I would say on a balance, whether you're talking about a balance of harms or you're talking about a substantial lessening of competition under a balance of probabilities, I think one of the most important things we have to keep in our merger review process, as exists in any other country's merger review process, is we need some materiality threshold. It's very important that there be some measure of materiality of effects. Whether we think about that as a substantial lessening of competition or a balance of harm. And the reason that's so important, especially if the efficiencies provision stays and we stick with a quantification emphasis, is that any economic model of a merger will predict some form of price increase. That's discussed at some length in the P&H decision. And the P&H decision is an interesting decision from the Competition Tribunal, because it actually shows that you can the Bureau has to meet some materiality threshold, even if there are no efficiencies that are being argued in a case, which was essentially what more or less was the situation with the P&H case. So I think on this overall question of kind of, do you have a balance of harms, or do you have a balance of probabilities when thinking about a substantial lessening of competition for a merger review? Whatever we do, we need some form of threshold so that we're not taking trivial expected harms and challenging them. I think neither the government nor the merging firms should really pay substantial costs of litigation. The recent rounds of litigation show that those costs are quite enormous, and we don't want to be taking those cases if if the expected harm or the effect on competition is minimal. tying this back to efficiencies, the problem on the efficiency side, as I said, is really coming about from this overemphasis on quantification. And so if you did away with the that overemphasis on quantification, let's say Section 96 was removed, which is one of the proposed amendments, then maybe you don't need to do anything about this balance of harms or how you might think of the legal standard. You might just leave that alone, because at that point you might have changed or removed this overemphasis on quantification that's going on with respect to the efficiencies defense. I'll make just a couple comments. I don't think there's any perfect reform to Section 96. I think it's a real quagmire that we're in. Given the jurisprudence, we should be taking more account of qualitative evidence, and courts do that regularly. They're totally capable of doing that. It's unclear why we have such a strong emphasis on quantification. If we were to remove Section 96 in its entirety, I think some of the cost savings, companies would still put forward cost savings as motivation for the transaction. Those cost savings still put downward pressure on price. Those would still be included in how we would think about the transaction's effects. We'd be missing fixed cost savings in that exercise. I'm not sure how much of a concern that would be. That I guess that's something that we'll see as we go forward. One other comment on this, and then I'll stop, is that if we were to remove Section 96, we probably end up with a slightly more Canada-centric form of merger review, in the following sense, that right now, when we think about the SLC side of mergers or the harm, we're always focused on Canadian consumers. On the efficiency side, a lot of the efficiencies cases have actually involved companies that have been subsidiaries of foreign companies. And so a lot of the type of cost savings that we've thought about for assets based in Canada have actually been, if you think of them as returns to shareholders or returns to those foreign-owned entities, they've potentially left Canada. So it might be the case that if we didn't have Section 96, we might have a slightly more Canada-centric merger review cost-benefit analysis. And I'll stop there.
Wonderful. Thanks so much, Margaret. Sandy, if I can just turn to you for your quick reactions to the merger review section of the ISED paper. You're on mute. Sorry, Sandy.
There we go. Okay. Thank you, Anthony. So I rather than comment specifically on what Margaret has said, which I thought was very interesting and insightful, I thought I'd focus on the merger notification regime potential amendments that the consultation paper raises. So this is kind of the nuts and bolts type of issue. Certain transactions are subject to notification under the Act. There are two thresholds currently. One is the size of transaction threshold that looks at the assets in Canada of the target, as well as its sales that are generated by those assets in Canada. In addition, there's a size of parties threshold that looks at the parties' combined assets in Canada and combined revenues from sales in, from, or into Canada. So there are a number of concerns about the current thresholds. There's a concern that some transactions that should be looked at are not being looked at. So, for example, there's a concern about using a book value of assets in Canada threshold. Its book value of assets is not necessarily indicative of how important a company is to the Canadian economy. You could have an IT type of company that has a fairly low book value of assets, but that is actually quite significant. Sales into Canada are not counted on the revenue side for the size of transaction threshold, which is really focused in on the target company. So there may be a legitimate concern that certain transactions that are significant to the economy are not caught by the current rules. There are a number of ways to address this. including, for example, adding in sales into Canada on the revenue side. Another concern that's raised by the paper is that nascent competitors, so startups or the WhatsApps of the world, are scooped up by large companies before they become a competitive threat. These are referred to as killer acquisitions, and they may not be notifiable where the targets are young companies and have low assets and maybe negligible revenues. So there's a concern that these transactions may, in certain instances, lead to a substantial lessening or a prevention of competition. The paper suggests potentially a longer term than 1 year for the Bureau to challenge these transactions, assuming they're non-notifiable. They also suggest shortening, having a longer limitation period, but shortening that if there's voluntary notification of such transactions. There may be questions, though, about Bureau resources to do that, and is that a good use of resources? So perhaps a more direct way to address this type of concern about killer acquisitions may be to use an enterprise value threshold for the target. An enterprise value is based on purchase price. It often includes adding in debt. And so that may be a better measure of the potential of a nascent competitor. And that metric is actually used under the Investment Canada Act. So I think I'll leave it there. And
right. No, thanks. Yeah, thanks very much, Sandy. Danny, if I can just turn to you for the view from down south as to some of the proposed changes up here.
So on the merger side specifically, I think there are two issues. You also see pushes in the United States to lower essentially the presumption. And in the United States, the overwhelming majority of cases have been government wins, those that actually get into court. And the question is, so then what's missing? So if part of what is missing is simply resource misallocation, that you can't go after the more marginal cases where it's more difficult, then the question is, do you need a different standard or do you need more resources? Because let's be clear, as Margaret correctly stated, it's not cheap to bring these kinds of cases. You need not only the internal staff, but you also need the resources for external experts, and it's just expensive. So if the question is, you're not winning the kinds of cases that you want to win, is it one of resource allocation, or is it the presumptions are off? So before changing the presumptions, perhaps the first step, and this is a wait and see type approach, and Canadian competition law and Canadian competition policy is really good about this. It's not a first mover on really just about anything, but actually takes best practices, perhaps better than any other jurisdiction around the world. So maybe the first step is actually let's give the Bureau the resources it needs and say, here it is. You need the resources. We're going to give you the resources. Show us your best cases. If it turns out these cases actually really are good cases, then that solves the problem. If it turns out these were actually really close calls, that's a different story. And then you do this other quantification exercise, which is to figure out in those close calls, which way does it go? But you haven't done that first step yet, which is properly resource the Bureau. The second issue is simply, how do you reach smaller acquisitions? If the concern is there are a bunch of acquisitions being made. So what's fascinating in the States is that this is focused on, for a paper that showed a potential mechanism on killer acquisitions, the paper was actually about pharmaceuticals, not about tech, tech is different than pharmaceuticals, but it also focused specifically on software tech, not hardware tech. And the mechanisms are different because you don't have the regulatory overlay. So in each of these cases, you have large companies essentially that have pushed the risk to smaller companies. And this is true hardware companies, software companies, and not just the companies that we call big tech, but also companies that are both big and tech. So you can think, for example, in the enterprise software space, Oracle is a serial acquirer and frankly, a much larger acquirer than Amazon is on a yearly basis and has been frankly for decades. So the question is there something unique to quote unquote big tech that is both big and tech and also has this moniker big tech? Unclear. So if the real question is, are there certain types of mergers that we're not seeing, and that would be number one. Then number two is, would the outcome be different if we did see them? And in that case, you actually have to have not just a theory, but you have to match the theory to the facts. And that becomes complicated. And then again, we get to something that I think Margaret alluded to, but I'll make more explicit, which is at some level, what's the cost of reviewing a lot more mergers, right? So there's a trade-off if these are mergers that on the margin are, shall we say, neutral, or potentially pro-competitive. And then there's the issue within pure competition policy as we think of competition law. But now I'll focus on something broader for a moment as to a broader investment strategy in Canada. So it's the story essentially of two colonies, and it's not Canada and the United States. It's actually Canada and Australia. If we look 120 years ago, the size of country and frankly, the economies of Australia and Canada were quite similar. Exports were mineral exports, some kind of animal protein, livestock, essentially, and some combination of grain, in Canada and Australia, and then this unique Canadian thing that is not grain, but not quite livestock, and we call it lumber. But overall, you look 120 years later, the year 1900 versus 2023, Canada is simply far surpassed Australia with the same language, same basic legal structure, but with a very transformed economy. Canada is a world leader with regards to innovation. Canada is a world leader in AI technology and with a number of not just homegrown companies, including in biotech, but also a massive R&D center for larger global companies. The reason why this matters is because if companies across the economy, both in Canada and globally, really care about innovation and the business model is to shift risk to small startups, and in fact, we applaud when startups fail on a regular basis because that's what they do, then we basically are, through a combination of scale and scope, are able to transform a business that couldn't make it on its own and integrate it better. That's something to be applauded. The problem is, with Canada, it's a small enough economy that if Canada gets the incentives wrong, that money, the venture capital money, will flow to those countries, frankly, where innovation will be rewarded more and that will have fewer regulatory burdens. So you definitely want to go after the anti-competitive mergers. No question about that. But if Canada chooses badly, it becomes the next Australia. And I don't mean that in a positive way. I mean, Canada has a choice, Australia or Singapore. Singapore is a hub for innovation, has more unicorns than most other countries, literally a magnitude of population much larger than itself, and why they've been tech friendly, tech broadly defined, and they really want to encourage investment. If part of Canada's differentiation in this world is to literally have biggest bang for buck, it means being pro-innovation. And you cannot think about a Canadian competition law change without thinking about this broader investment strategy, particularly at a time of global retrenchment So the opportunities are simply fewer, and the opportunities are much more North American centric right now with regard to supply chains. Canada might lose out for US based investment, and that is potentially existential when we look at the ability of Canada to reap R&D benefits economy-wide. I'll stop there.
Wonderful, thanks, Danny. You mentioned the focus on big tech with regards to mergers. There's also a focus on big tech with regards to unilateral conduct. Quite a number of changes, proposed thoughts going on with regards to the focus on big tech and how they're behaving. Sandy, if I can turn to you, can you talk just a little bit about some of the recent changes in the BIA had some changes that Ed talked about. Perhaps you can talk about some of the more dramatic changes that are being previewed here in the consultation paper.
Sure, thanks, Anthony. So as Ed said, there were a number of changes that were pushed through pretty rapidly through the Budget Implementation Act. Those changes did broaden the scope of the abuse of dominance provision, but I won't go into that. So what we see in the ISED consultation paper is the government stating that it appears that the three elements of abuse of dominance that the Bureau has to prove, namely that there's a dominant firm, a practice of anti-competitive acts, and a likely substantial lessening or prevention of competition. The ISED consultation paper suggests that proving those three elements is too onerous a burden for the commissioner. I'm not sure this is necessarily the case, and I think I'm going to echo the comment. I don't know whether it was Danny or Ed, but losing, if the Bureau loses a case, it does not necessarily mean that there's something wrong with the law. And it isn't actually clear to me that at this juncture, there are significant deficiencies in the abuse of dominance provision. And it might make sense to actually wait and see the impact of the changes under the 2022 amendments. As a general point, I'm going to zero in on two changes, but as a general point, the ISED consultation paper on the issue of unilateral conduct, as well as other issues, presents kind of a potpourri of options. And I do hope that legislators will consider how the proposed amendments operate holistically or as a package. For example, if you combine some of the options in the consultation paper together, like eliminating intent requirements or lowering requirements for harm in relation to Section 79, you could end up with a provision that could apply very broadly, be uncertain, lead to a chilling effect on pro-competitive or neutral conduct. So there are some real concerns there, but I'm going to, in my limited time, zero in on two issues raised by the consultation paper. One is bright line rules for dominant firms or platforms, and two, adding a fairness provision in the Act to address unilateral conduct concerns. So to deal with the first, creating bright line rules for dominant firms, the consultation paper suggests that this might be a way, and this might be a way to address concerns about dominant firms, particularly in the digital economy. And the bright line rules might be in the form of a code of do's and don'ts, as is being pursued in the European Union through the Digital Markets Act. The DMA applies to gatekeepers, who are large online platforms that meet certain criteria. By establishing rules prohibiting certain conduct, the DMA, I understand, does not require an investigation into actual effects on the market of that conduct. In my view, it's not clear that in Canada we need to go this route. I think the existing dominance provisions can address concerns arising from anti-competitive practices of dominant firms. For example, I think one of the concerns raised in the DMA, or one of the prohibitions, relates to self-preferencing by large online platforms. Well, I think that can be addressed under Section 79. We've seen, sort of broadly speaking, self-preferencing exclusionary conduct caught by 79 in past cases. So it's not clear to me that, you know, we need a code to, you know, a list of rules effectively for dominant firms. And the other point is, although dominant firms may share bigness, they may have different business models and different products, which means that different rules may have different impacts on such firms. And it may be that having these ex-ante rules may not actually have a negative impact on competition, may in fact increase costs and lower incentives to innovate in certain scenarios. So I'm not in favor of moving away from looking into the competitive impact of large firms' conduct on a case-by-case basis. It's also unclear which large firms such rules would apply to. There's, you know, a lot of the concern in the consultation paper relates to the digitalization of the economy, and that does not just apply to certain sectors like tech, it applies across the board. The other thing is there's a cost associated with a regime of ex-ante rules. The Competition Bureau would need to have resources to monitor compliance and to take enforcement action. So I think basically I would favor you know, retaining the current abuse provision. We can see how the European Union fares with its Digital Markets Act. We can look at the impact that might have in Europe. And if there's a concern about certain types of conduct and there's a desire to flag that this particular type of conduct could be anti-competitive, it's always possible to add to the non-exhaustive list of examples of anti-competitive acts found in Section 78 of the Act. So that's what I wanted to cover on the ex-ante rules. The other issue that I wanted to focus on relates to what I said its consultation paper referred to as repositioning unilateral conduct provisions to focus on fairness. And this may or may not include the abuse provision. But I don't have a long commentary on this particular idea. Fairness is a nebulous concept. It does not, it's very difficult to define. Fair to whom is one question we might have. We don't have 100 years of jurisprudence on what fairness means. So there would need to be some guidance for business as to what behavior is acceptable and what is not acceptable. Otherwise, there's a very high probability that fairness would be interpreted too broadly and lead to over-enforcement, especially if there is private enforcement of that provision. So this could have a chilling effect on pro-competitive behavior by companies. We do have a hodgepodge of provisions under the reviewable practices part of the Competition Act. It is a bit messy, there's overlap, but at this point in time, I don't think a concept of fairness is the way to solve that concern. And I think I'll leave it at that.
Great, thanks so much, Sandy. Randall, you've been incredibly patient. If I can turn to you for your thoughts on the unilateral conduct section of the ISED consultation.
Great, thanks, Anthony. So what I'd like to focus on is the second item for consultation in this section of the consultation paper, because it seems a bit curious to me. And it reads, quote, crafting a simpler test for a remedial order, including revisiting the relevance of intent and or competitive effects, end quote. Now, I say this is curious because, first of all, the consultation paper contains no discussion of this specific topic, let alone identifying any remedial shortcomings of the law or the role of intent or competitive effects in remedies. The last discussion point in this section relates to converting, as Sandy just said, the unilateral conduct provisions into a, quote, single principle-based abuse provision. So this simpler test discussion point must be something different, and it's unclear what that difference is. As for the role of intent, there is no requirement that subjective intent be established in any element of the current abuse law, only objective intent, and no indication in the consultation paper that the Bureau has had any difficulty in making that proof. Moreover, a case may even be made for a subjective standard in an area of competition law rife with uncertainties and which now can be sanctioned by treble damages, or if that's incalculable, 3% of global turnover. These new sanctions are, of course, more onerous than the dollar sanctions available in private actions for criminal conduct, where intent is front and center. And they dwarf any criminal fines that have been rendered to date in criminal cases. Now, I'm again not clear as to the reference to competitive effects, but I would say on that any remedy should remain dependent on establishing that the impugned conduct has had, is having, or is likely to have anti-competitive effects. If, as the paper muses, the Bureau need only establish that the conduct is capable of having such effects, it seems that we're bringing the abuse provision closer to a per se provision. Now, of course, one cannot forget that the tribunal has suggested already that the anti-competitive effects test in Section 79, especially as regards quantification, and with the absence of an efficiencies defense, is already less onerous than the anti-competitive effects standard in mergers. So again, maybe to echo what Ed said, it's unclear as to some of these, what's intended by some of these discussion points. And I think that lack of clarity will make it difficult for folks to comment meaningfully.
Thanks very much. Ed, if I can just quickly turn to you for some of your reactions, either to the paper or some of the comments today.
Yeah, maybe a little of both, but I've appreciated all the comments on both mergers and unilateral effects. I just want to pick up on something that sort of both Sandy and Danny have said and just tie them together. One of the things that's concerned me a little bit, and back to how this process initiated, is that you sometimes see this framed this way, that, boy, there's all these changes in other jurisdictions and Canada is falling behind. We've got to catch up. As opposed to just that these are changes, they may be good or they may be bad, but there's change, but that doesn't necessarily mean that we need to change too. But you see this kind of, we're not doing what our trading partners are doing. We need to do more. And I just want to connect this to Danny, and I think Sandy both alluded to this. I think there's the fact that it's happening elsewhere actually makes it easier for us not to do anything because we can kind of learn what's happening elsewhere. Let's take advantage of the fact that they're willing to impose some pretty potentially costly rules, maybe beneficial rules, but we can kind of wait and see in a manner that, to me, if anything, what's going on around the world reduces the case for Canada to change, not strengthens it. And then the other point I just wanted, and that includes the impacts on unilateral conduct, in particular the self-preferencing thing that the DMA is going to be struggling with defining, I think, for quite some time before they make a lot of progress. I just want to say something else very quickly about the fairness in the unilateral conduct, and that is just to say, my own view is that the purposes of Canadian competition law are at this point this kind of a jumbled mix in Section 1.1. There are various ways that one could deal with that. The paper I wrote for Senator Weston goes over some possibilities. There are others, obviously, as well. What I found sort of slightly odd about the ISED consultation paper was that it said, in fact, we're assuming for ease of discussion, it says, that the purpose clause remains the same, quote, for the most part. So a couple things are odd about that. One, this is a paper on the future direction of Canadian competition law. I'm really not sure why we wouldn't want to actually just take a moment, or at least have the possibility of a discussion about its foundations before we get into the particulars. This seems to me to be something we should not sort of just assume, but actually interrogate. And then the other is the for the most part, because it actually then has these moments where it does seem to be pushing in new directions. Fairness is one. Labor kind of fairness to labor, it seems to be another one that did come up. And that's where I think the for the most part came in, because they do seem to have attention to labor that they didn't otherwise, hadn't otherwise paid. So I think that's, so it's, I'm a little, I share some of Sandy's concerns about fairness, but also think that if we're going to have this as a discussion, let's have it as a discussion. Let's not kind of just tuck it into the details of particular provisions. Let's have that broader discussion.
Thanks very much, Ed. With our last 10 minutes, I want to turn to competitor collaborations. The ISED paper discusses algorithmic collusion. It discusses potential expansion to the civil provisions. Randall, I was wondering if you get your reactions to that section on the paper.
Certainly. So as I think you said, the consultation paper has kind of 3 points of discussion on competitor collaboration. One is horizontal coordination without agreement. The second is the scope of civil enforcement. And the third is buy-side coordination. I think I'm going to focus here on horizontal coordination without agreement and buy-side coordination. They're kind of related. Now, the horizontal coordination without agreement section of the consultation paper is seemingly focused on the potential for algorithms to result in de facto coordination of pricing. The paper calls it tacit collusion, but that, of course, can be subject to Section 45 if it is indeed collusion. So it really seems that the paper is focused on, I'm going to call it computer-assisted conscious parallelism. And the suggested discussion point on this topic is whether the law should allow a decision maker to deem or infer an agreement more easily for certain forms of civilly reviewable conduct, such as through algorithmic activity. That's the discussion point. So on this, my first note is that for civilly reviewable conduct, proof of an agreement is already easier. It's on the balance of probabilities, not beyond a reasonable doubt. My second observation is that these issues were identified by the Bureau in the digital consultations a few years back, and the Bureau did not suggest a change to the law was warranted. And there's nothing in the consultation paper that suggests something has changed on that front in Canada, other than perhaps some foreign authorities being more focused on this and additional academic commentary. My third note is, if the concern is the effects of the use of artificial intelligence on competition or even on prices, absent any agreement, then this is an issue that's outside the scope of this specific discussion point, which is about inferring agreements. The discussion point confirms the importance of the agreement for liability in suggesting that it can be inferred or deemed. So if what is at issue is broader than proving agreements, and there is actual evidence of algorithmically facilitated coordination without an agreement, one needs to very carefully consider whether the Competition Act is the correct tool to, quote, regulate that. Indeed, in footnote 103 of the consultation paper, the Bureau even notes that Bill C-27, which is called the Artificial Intelligence and Data Act, if passed, may provide an avenue to address this conduct. So it seems prudent to me to let Bill 27 process to play out. Clearly, this law in Bill 27 need not focus on inferring agreements or liability or moral culpability, but on the effects of any algorithmic conduct on the public interest. So in the section of the paper called buy-side coordination, the paper notes the political storm and subsequent indue report that led, at least in part, to the wage fixing, no poach, and no solicit amendments to the Act's criminal provisions in June of 2022. And it fairly points out that buy-side agreements of any type have never been per se unlawful in Canada. And that buy-side agreements can, and I'm quoting, reduce costs, increase efficiency, and deliver consumer benefits. Now, having said that, the paper then shifts to suggest that because labor markets have been found to be, again, I'm quoting, capable of harm, comparable to those in product markets, it is not a stretch to apply the other forms of naked buy-side coordination that distort markets to the detriment of suppliers. Now, no examples of such agreements are provided in the consultation paper, yet the paper proceeds to suggest that all buy-side agreements be subject to the per se Section 45 criminal provision, and that the fact that many of these agreements are pro-competitive be addressed through exemptions, or alternatively, that these agreements be subject to civil review without requiring any proof of anti-competitive effects. And the discussion point focuses on those two options. And my observations quickly in that are fourfold. First, a conscious decision was made by Parliament after years of consultations, a little over a decade ago, to exclude buy-side agreements from per se criminal liability. And the consultation paper and the Bureau has not set out a basis for concluding that that decision was ill-advised at a general level. Second, the consultation paper itself seems to recognize that per se criminal law is too blunt a tool to deal with competitor collaborations on the buy side that often have pro-competitive effect and may otherwise be in the public interest. For example, in the public's interest in the environment. Third, rendering an agreement subject to prohibition without requiring proof of anti-competitive effects seems antithetical to the Competition Act. Moreover, the very reason that the current Section 45 is per se offense for supply side agreements to fix price, control price or output, to allocate markets, the very reason is that Parliament concluded that those specific agreements always had anti-competitive effects. Thus, it was unnecessary to require proof. Even then, Parliament provided parties with the ability to show that the per se agreement was ancillary to a broader agreement that was not anti-competitive. So to suggest that there be no requirement to prove that buy-side agreements causes a substantial lessening or prevention of competition seems to me a radical departure from the framework in the Competition Act, and an amendment that would clearly chill competitive collaboration. And finally, Anthony, and perhaps this is an aside, personally, I would suggest that any amendments in this area focus on fixing the issues and uncertainties that have arisen from the recently enacted wage fixing, no poach, and non-solicit provisions.
Thanks very much, Randall. Margaret, if I can turn to you just quickly for a couple of minutes to talk about some of your reactions to that section.
I'll make one reaction to what Randall said. A lot of the economics literature in respect of artificial intelligence is about, it is unilateral conduct. It's not agreements among firms. It's unilateral conduct in the sense that it's optimizing how to price for an individual firm. And so it does seem to, I agree fully with Randall, it seems odd to have this under section, some kind of collusion type section. And then the only other comment I would make, also agreeing with Randall, that it doesn't, to me, make much sense to remove any the substantiality, as I had said earlier in the mergers provision. I think it's really important that we always have a materiality threshold of some form, and that should be that there should be some form of competitive effects or competitive harm that's coming about from whatever the sections are designed to be. So I agree with Randall, it doesn't make any sense to be removing that in the context of buy side or any other or supply side agreements among firms.
Thanks very much. It looks like we've run out of time. There's so much more to say about so many of these topics, and I know we're all itching to talk about all three topics that we discussed. We also could have talked about some of the broader changes to the Bureau's powers that's covered in the ISED paper. What we learned from this is there's plenty of opportunities for consultation, and we should take those opportunities where we can take them. Thank you all so much. Margaret, Sandy, Danny, Randall, and Ed. Thank you so much for joining us. Thanks very much.